I'd like to call this special meeting of the Ethics Commission to order. We'll first take the roll. Commissioner Studley?
Here.
Commissioner Liu?
Here.
Commissioner Hayon?
Here.
Commissioner Rennie?
Here.
I'd like to also introduce counsel for the Ethics Commission in this matter, Scott Embledge of the firm Moscone, Embledge, and Sater, sitting in the front there. Before we begin, Mr. Rennie has an announcement he would like to make.
Yes, in a spirit of full disclosure, I want to say that as the record will show, I was appointed as an ethics commissioner on February 8th of this year, prior to the time that I would be subject to the restrictions insofar as campaign contributions. In late October, early November, I was asked to make a political contribution to Sheriff Mirkarimi's opponent, Chris Cunney. And I made a contribution, as I recall, of about $100. I assure the sheriff and his attorneys and the mayor's attorneys that the fact that I may have made that contribution, and I will say I've never met Mr. Cunney either before or after that time, but that the fact that I made that contribution, I approached this hearing totally with an open mind, with no preconceived notions one way or another as to where this hearing should come out.
Thank you, Mr. Rennie. A couple procedural matters before we begin. Public comment in this matter will occur at the end of the hearing and will be limited to 2 minutes per person. When we get there, I'll provide these instructions again, but we would like people to just line up 4 or 5 at a time, and then when the 5th speaker has finished giving public comment, 5 more can then line up. This is to ensure an orderly process and to make sure that we comply with all building regulations. So the item on the agenda is the official misconduct proceedings that are now before us. I would invite the attorneys for the mayor and the sheriff to please come up and state appearances.
Good afternoon, Commissioners. Peter Keith, Deputy City Attorney, along with my colleague Sherry Kaiser, Deputy City Attorney on behalf of the Mayor.
Good afternoon, Commissioners. My name is Shepard Kopp, and along with David Wagner, my co-counsel, I have the honor to represent Sheriff Mirkarimi.
Thank you, Counsel. Mr. Keith, I understand that you, an hour or so ago, circulated a memo. I trust that counsel for the sheriff has received this memo?
We did send it to them.
We have it.
Okay, thank you. Given that we just received it, I'm not sure all the commissioners have had a chance to review it, and I know that no copies have been made available to the public because we just got it, but we will make it available on the website as soon as we can. The Ethics Commission staff has put forth a memo suggesting procedures that would govern this official misconduct hearing. I'd like to ask my fellow commissioners whether it makes sense to first hear from the parties on their views before we conduct our deliberations about how the procedures should be implemented. Any objection to that?
That makes sense to me. No.
Okay. So, Mr. Keith, perhaps we can first hear your views on the procedural memo that was the Commission has put together and your views on what was set forth therein.
Thank you, Commissioner. The Mayor's goal in these proceedings is to make sure that there's a full and fair proceeding in which the Commission is going to have an opportunity and the public is going to have an opportunity to hear all of the evidence that's relevant to the determination of official misconduct in this matter. And we've made our proposals in that spirit in our response to the Executive Director's thoughtful memo in that spirit. One thing that's become clear over the past week with regard to the sheriff's public statements in various media outlets is that the determinations that the commission is going to make here and the recommendation that it's going to forward to the Board of Supervisors is going to involve the resolution of credibility disputes. It's going to involve hostile witnesses. It's going to involve a lot of witnesses who don't work for the city, and so who really can't be compelled to sit down and draft up a written declaration. So I think what our feeling is on the side of the mayor is that a live hearing is going to better serve the goals of the commission in determining the facts of what happened here. There's nothing like having a live witness subject to both direct examination and cross-examination in order to weigh that person's credibility based on their demeanor, based on issues that may come to light in the course of other witnesses' testimony. And so our proposal to the commission, which we submitted in our memo, and I'm happy to summarize here, is really directed toward a live hearing. There's a lot of commissions in the city and county of San Francisco conduct live hearings on matters like this, from the police commission that conducts matters related to police discipline to the Civil Service Commission that addresses matters under its jurisdiction. They hear live testimony. They have something of a mini trial, and that's what we think is going to best serve the goal of ascertaining the truth here and making a complete factual record to forward to the board. Do you have any objection to first submitting briefs to outline the legal issues and to put forth your factual evidence so that we can determine where the actual factual disputes are before entertaining any live testimony? We would be able to summarize the facts in our case for the commission. I think it's unlikely that we would be able to get essentially sworn declarations from a lot of these witnesses, but we would certainly summarize what we expect their testimony to be if the commission thinks that that would be helpful in making the determination whether a live hearing would be helpful. I presume that there are some witnesses that are within the mayor's ability to obtain a declaration. Is that? Oh, certainly. Yeah. I mean, any city employee could certainly execute a declaration. Our concern is more with the folks who aren't city employees, who we don't necessarily have that power over. We could ask them to. They might, in fact, do it. But I have a feeling that the cross-examination of those witnesses would be so long and arduous, and the redirect of those witnesses would be so long and arduous that it would be more considerate of the witnesses' time on both sides to simply call the witness in and have them testify live. Again, the submission of declarations involves a lot of effort. We would ask them to do that if that's the commission's decision, but we don't think that it's helpful, that it's fair to the witnesses, or that it's the most helpful way for the commission to reach its decision. Mr. Keith, a few questions, and I would open it up to my fellow commissioners as well, and then we'll hear from Mr. Kopp and perhaps again from you. The mayor has suspended the sheriff without pay. Is that correct? That's correct. And so presumably he did so on the basis of known facts. In other words, the complaint was not filed as mere allegation, as notice pleading. This was the mayor had within his possession facts that form the basis of the allegations, or at least in the mayor's view, that's what he has. He absolutely did, and what he didn't have and what he still doesn't have are documents that would help resolve some of the credibility disputes that we expect to arise, documents like telephone records. For example, telephone records of the various communications on January 4th that the mayor has alleged constitute witness dissuasion. Those telephone records will tell us which witness called which witness when, and it'll help us map out the communications that happened in the course of that day that the mayor contends gives rise to witness dissuasion. And so the mayor doesn't have evidence like that. What the mayor did have was statements from some of the people involved in the communications that certainly, in his mind, gave him probable cause to feel that this official misconduct had occurred.
And of those people he spoke to or from whom he obtained evidence, those people would be able to submit declarations?
Some of them are independent witnesses. They are cooperating with us, but there's a difference between having a short interview and sitting down and writing a declaration under penalty of perjury. I can't say whether those witnesses would be willing to cooperate with us. We certainly can't compel them to.
So your view is you had enough to put together probable cause charges based on these statements, but you're not sure you would be able to get them to submit sworn declarations to the same effect?
The process of drafting a sworn declaration and having the witness go through it and make sure that everything is
I'm
just
aware of
so
that process.
it's long and difficult, and not all witnesses may be willing to do it.
Other than the person you identified in your memo, Ms. Haynes, is there anyone that you contemplate anyone else who you think you need testimony from who you do not at this point anticipate getting a declaration from?
Sheriff Mirkarimi would be one.
Anybody else?
Ileana Lopez would be another.
Okay, we'll talk about that. As far as Ms. Lopez goes, what is the basis for being able to compel her testimony?
Well, the subject matter of her testimony would be relevant to a matter that is under consideration by the Ethics Commission, so we would think that a subpoena to her under the charter would be proper.
Anybody else?
Let me look at my witness list. There are at least three other witnesses who are independent witnesses who have cooperated with us. We would hope that they would show up, but we would likely want to subpoena them in order to ensure that they appear before the commission.
Who are they?
Abe Mertens, Ivory Madison, and Callie Williams.
Who? I'm sorry, the first one was?
Abe Mertens.
Abe Mertens. Other questions from the commissioners for Mr. Keith at this time?
Mr. Keith, I just have, I think, one question. That is, how did you, I read the memo very quickly, but how did you perceive this live hearing to proceed? Like a trial, that you would submit trial briefs, each side would submit trial briefs outlining what you intended to prove, and then you put your evidence in, and then to close, submit closing briefs as you would in court, and then we would act on that record that you put before us? Is that what you had in mind?
That's our best guide. I mean, I think in the sense that the other administrative agencies proceed in a similar way, like my reference to the police commission, for example.
Have you discussed this at all with Mr. Kopp?
No.
Okay.
Other questions from the commissioners? Commissioner Liu?
Mr. Keith, so the complaint or the charging document does contain several factual allegations. So is it your view then that we would have to find each allegation to be true in order to sustain the charge of official misconduct?
The commission would, the commission, number one, would make a recommendation. The charter doesn't specify whether there can be multiple recommendations, whether there can be a majority and a dissent. It doesn't prohibit that. My assumption would be that the commission would make findings of fact, that where there are credibility disputes, it would make credibility findings. And then as to each charge, if any one charge is sustained, then official misconduct has occurred. And that's ultimately a decision for the Board of Supervisors to make. But we would envision the Ethics Commission making a finding as to each charge.
But as to the specific factual allegations in the complaint or the charging document, would we have to resolve any credibility issues in your favor and find the allegations to be true in order to recommend that the charge of official misconduct be sustained? Is that what you're saying?
I think yes, as to most, if not all of the charges, there will be credibility disputes, and there will be factual disputes as to, for example, the effect of probation on the sheriff's ability to perform the duties of the office of sheriff with regard to probation. I mean, I don't expect the other side to agree that he's rendered unable to perform those duties, or that even if he is, that renders him unable to perform the duties of office. So I expect there to be disputes even on issues that are, I guess, less driven by, I guess, a swearing contest than other issues.
So you would envision calling witnesses on that point as well, on just the discharge of duties, what it entails? That's
correct. And
I see.
there may be some areas where we would be able to stipulate with the other side as to the facts, but I have a feeling that those stipulations would really be confined to very dry historical facts, and I doubt that we would be able to stipulate to issues related to the ability to perform duties and fitness for office.
I see.
Commissioner Han?
As the only non-attorney in this group here, if we were not to have an evidentiary hearing with live witnesses, what would that alternative look like? Would it simply be a matter of going through written documents as a group?
Well,
reading them publicly? What would that look like?
Well, I think that what the executive director proposed in his memorandum was that each side would essentially submit in writing what their friendly witnesses would be expected to say if they were here live. That works to some extent, but I think that a lot of the records that we may be looking at, telephone records, for example, they're not. It's not self-evident necessarily what's going on if you just look at a page of telephone numbers, and those are kinds of records that could use interpretation. Where, say, a witness says, "I had 2 telephone calls with this individual in the afternoon." We might want to have that record in front of us while we're having the witness answer questions, so we can try to ascertain which of the entries in the telephone record correspond to those calls. Things like that are very difficult to do when one is sitting alone reviewing a declaration.
Commissioner Sedley?
Following up on Commissioner Hand's question, the staff recommendation was that we brief the issues and then the commission make a determination whether it was necessary to have live witness testimony and as to what players. How would your recommended procedure differ in terms of the briefing and the time that it would take? I'm asking for us, but
Yes.
I also think it might be of value for the
Certainly.
to understand those consequences.
What our proposal would be that the commission take briefing immediately on 3 issues. The first issue being what the standard of proof is, which is one of the bullet points in the executive director's memo. The second issue would be essentially a proposal for rules and procedures that would govern this live hearing. What would this mini trial look like? And we don't need to start from scratch with that. Other commissions, like, for example, the Police Commission, has a set of procedures that govern hearings and also provide for pretrial disclosure, or pre-hearing disclosure of evidence from one side to the other. So those would be matters 1 and 2 to brief. The third issue that we would request immediate briefing on, and this is one that's raised in my memo but hasn't come up yet, is the issue of whether Sheriff Mirkarimi is going to make a claim that he has an entitlement to a hearing that's closed from the public. Commissioner Mirkarimi is a peace officer, and under Penal Code Section 832.7 and under the Copley Press decision of the California Supreme Court, there's a potential argument that he could make that he's entitled to a closed hearing, essentially as a peace officer, and this being a personnel matter. We disagree, but we think that it's incumbent to raise this issue at the very beginning because we don't want to put all of the work into this decision and have it be undone by some procedural defect at the outset. So we would want, if Commissioner Mirkarimi is not going to waive an entitlement to a closed hearing, we would want that issue to be briefed immediately as well.
Do you object to briefing the other legal issues that were set forth in the commission's staff memo?
I think that
those seem to be sort of precursor issues as well.
Well, let me put it this way. We just briefed them to the Superior Court, so we could brief it, but I think that briefing on these issues makes a lot more sense in the context of the facts as they're going to come in. Because for example, when you're considering the official duty, what constitutes an official duty, when is somebody who's elected sheriff on duty, it's important to have the facts of what that individual is doing between the time of election and being sworn into office. It's important to have the facts of what that individual's job duties are going to be when he gets into office. It's important to know what codes of conduct apply to law enforcement officers, where an act that happens perhaps before somebody starts in a position, whether it's as the head of the sheriff's department or just a deputy sheriff, whether that conduct that occurs before they take the position can effectively disqualify them from performing the duties of office effectively. So I think that these legal questions could be answered in the abstract, and if the commission directs us to, we certainly will. But I think that these are tough issues, and I think it's better for the commission to be able to grapple with them in the context of real facts and evidence that we would get.
So then you would propose significant post-trial briefing after the evidence is heard?
Certainly, as well as proposed findings of fact.
Commissioner Studley?
The staff memo, in speaking about the need for examination of witnesses, seemed to anticipate the possibility that it be case by case, that the commission could determine which witnesses we felt a need to see in person and what testimony we could handle on the papers proposed in argumentation. Do you agree with that? Do you see this as more of an all or nothing presentation of the witnesses, leaving aside those as to which there's complete agreement about what the offer of proof would be and the acceptance?
Well, I think as a practical matter, once we start dealing with particular witnesses and the need for live testimony for particular witnesses, that exception will end up swallowing the rule. I think we're going to have a situation where you'll want to hear live testimony from most, if not all, of the witnesses, or each side will want to cross-examine each declarant for the other side. So I think that it's better to just make the witnesses go through this process once, and I think it's also better for the commission to be able to do it once, because often with declarations there's more questions that seem unanswered than seem answered. So I actually think it would be more efficient for the commission to simply take the live evidence. There may be some witnesses where the two sides can agree on fairly uncontroversial matters, and to the extent we can do that, we'll make every effort to do that. I mean, we don't want to call someone in here to give testimony on essentially an uncontested matter. I think under those circumstances, it's fine. But for the witnesses that I mentioned earlier, the independent witnesses, I think there's no question that they're going to be subject to extensive cross-examination. That's going to require redirect on our part to fill in the blanks. So I think ultimately we all save ourselves and the witnesses a lot of trouble. Because remember, these witnesses, they don't work for the city. They didn't ask, to be called as witnesses. They didn't ask to write declarations. To the extent that they're cooperating with us, they're cooperating out of a sense of civic duty, and I think we owe it to them to not make this burden on them so heavy.
I mean, Mr. Keith, we'll talk about this with Mr. Kopp, but the burden of submitting a declaration, I think, pales in comparison to the burden of actually having to testify in a proceeding like this. So, if anybody can, submit a declaration and not have to testify, I think they would likely agree the burden would be much less than having to testify in lieu of a declaration.
Oh, I agree. And if for those witnesses who we think it would end with just the declaration where it's uncontroversial, cross-examination isn't necessary, we have no problem submitting just declarations for those witnesses.
Does the mayor dispute that he has the burden of proof here?
No.
What about timing? When would you anticipate being ready to call witnesses if live testimony were permitted?
Well, that depends on the outcome of a lot of proceedings that are going on right now. What we've detailed in our memo are several instances of hostile witnesses and non-cooperation on the part of the sheriff. This has forced us to use the mayor's subpoena power to get documents. It's forced us to go to court to get orders to people to comply with subpoenas, and also to go to court to get an order to release evidence from the criminal court. So assuming all those chips fall into place and nobody makes any objection, which frankly is an assumption that I doubt would ever happen. We expect to be fought every inch of the way on these things. Assuming that those court dates came and the subpoena dates came and we got that evidence without objection, we'd be ready to proceed in June. But I very much doubt that that's going to happen.
Any other questions for Mr. Keith at this time? Thank you, Mr. Keith.
Thank you.
Mr. Kopp?
Thank you, Mr. Chairperson.
So I don't know when you got this memo, but have you had an opportunity to review it?
I have.
And what are your views on the procedural schedule outlined by the Commission, the proposed procedural schedule outlined by the Commission, and the response from the mayor?
If I could, I'd like to preface my remarks that I think at the outset we need to make our objection known and plain to any of these proceedings occurring. Because the mere fact that we're here to try to figure out the rules by which this process is going to work demonstrates the constitutional infirmity of the proceedings, and we object. We object to the Commission doing anything other than dismissing the written charges of misconduct and bringing the proceedings to a halt. Now, having said that, I think I'm enough of a political realist to realize that we're going to have to go forward with the proceedings. I don't think that we have a fixed in stone position as to the proper order to do things. I can tell you that until we understand what the mayor's evidence is or what his proposed evidence is, there is no way that we can formulate what our response to witnesses or testimony would be. We have the same information that you have, the written charges of official misconduct, but what I think I just heard Mr. Keith say is we don't have the evidence to support those charges. The charges were brought before the evidence was in the mayor's possession. So we need to know what they are going to present before we can figure out how to respond. That's number one. Number two, we urgently need clarification from this Commission as to whether or not Sheriff Mirkarimi is required by law to cooperate with this, quote, investigation, unquote, that the city attorney has embarked upon. And as Mr. Wagner and I wrote in our letter to the Commission, and I trust everybody's received a copy of that.
Which letter are you referring to?
We transmitted a letter to Mr. St. Croix this morning with numerous attachments, and I assumed it had been delivered, and I apologize if it has not, and we will rectify that at the earliest opportunity. Let me try to summarize the contents of the letter. The city attorney has been trying for a week or more to get Sheriff Mirkarimi to turn over his lawyer's files from the criminal case, to sit down for an interrogation, all under the authority of an alleged unbounded city attorney right to investigate. Now, the charter provisions that I have looked at indicate that if there is an alleged violation of the San Francisco Campaign and Governmental Conduct Code, a complaint may be made to this Commission, and it is this Commission that decides to initiate the investigation, and the city attorney may participate in that investigation. I don't see anything in the charter or any other statutes that permit the city attorney to go out and start their own investigation. we need clarification on that issue immediately and urgently. Because it seems to us that we'd be fighting with one hand tied behind our back. If they can go out and prepare whatever they need to prepare to proceed with this proceeding before you all have even promulgated rules of procedure that will hopefully proceed in an orderly fashion. Now, I did want to address one point that Mr. Keith made. We do not intend to argue that these proceedings need to be private. Indeed, we think they should be public because I think at the end of the day, there's a lot of innuendo and talk about the sheriff dissuading people. The mayor's written charges say he may have tried to get someone to dissuade a witness. And I want everyone to mark my words. When this is all done, it's going to be crystal clear that the sheriff did no such thing. And we want that to be known to the public of San Francisco. Now,
Okay, so let me just stop you there. So there is no dispute that Penal Code Section 832.7 should not apply to these proceedings to the extent that it would otherwise require them to be confidential.
correct. Now, with respect to briefing schedules, both prior to the taking of testimony, whether it's by way of declaration or by live witnesses, I could answer almost all the questions that the commission raised in the memo right here. I could tell you what we think the burden of proof should be. I could tell you what evidence we think you should rely on and go all the way down the list if you'd like me to do that. We do have an interest in accelerating the proceedings as quickly as possible because we think the longer this drags on, it's not only detrimental to Sheriff Mirkarimi, but it's detrimental to the city. So we are not in favor of lengthy briefing schedules, pre-trial, post-trial. I think Mr. Keith is perfectly able to get up here and argue at the conclusion of this process why he thinks they've proved the charges for the mayor, and we can certainly do the same orally. I don't think this all needs to be set forth in written fashion. Of course, if the commission thinks that that would be beneficial, we will certainly cooperate.
If the commission did want written briefs on the issues set forth in the commission memo, how quickly would you want a system where, or a procedure where the mayor would go first, submit an opening brief, and you would respond? Would you prefer simultaneous briefing?
The former would be preferable to us, just as it would be preferable to us that they disclose what evidence it is that they intend to rely on so that we can prepare to respond. I think it's got to be, I mean, to me, this is somewhat akin to a criminal prosecution in a sense. And one of the reasons why I made my objection earlier to these proceedings is in a criminal case, if a defendant was hauled into court and a judge told him, you've been charged with a crime by the DA over here, now we're going to figure out what the rules are and what the standard of proof is, I don't think anybody would be happy there. We think it's essential that they tell us what they intend to prove so that we can respond and have notice. Notice is the hallmark of due process, and that's what we're trying to make sure happens here.
So what would, sensitive to the fact that you would like the proceedings to go as quickly as due process allows, what would that briefing schedule look like in your mind, if you could set it?
Well,
if you could set it.
I think it's dependent on when the mayor thinks that he's got all the evidence he's going to need to present. In terms of the legal issues, the legal questions that are raised in the commission's memo, as I say, I think that we could receive their memo as soon as it was prepared and respond within a week or so to whatever they file. Certainly on the legal questions, the standard of proof. One point that's not on here is whether or not the commission has to vote unanimously to recommend removal or the sustaining of charges. We firmly believe that should be a requirement. We analogize these proceedings to the existing system under the government code, sections 3060 through 3075. Under that state scheme, the accused official enjoys all the protections that he would under a criminal indictment. And we think that those concepts should be imported into this proceeding.
If the brief included responding to factual statements, how would that change your time frame, if at all?
It would significantly extend it, because until we see what their facts are, we can't really begin. I mean, look, we have a general sense of what they're going to try to prove and how we're going to try to meet it, but, you know, the devil's in the details. So maybe there's something out there that we don't know about. It's awfully hard for me to tell you we would need 30 days or 21 days. We would need significantly longer than a week if this was going to address factual issues.
Do you have a position on the need for live testimony?
I think it's probably going to be unavoidable for at least a couple of witnesses. I'm not necessarily opposed to having declarations submitted for those who can and will submit them. And then if either side thinks, well, we have a dispute of fact on this one particular issue, we would like to call the declarant to cross-examine them on that issue, submit that, the commission makes its ruling as to whether or not we can or can't do that and go forward that way. But I think there are a couple of points that are probably going to be straight credibility calls that are going to require observing demeanor of a witness.
Do you have a position on whether Ms. Lopez can be compelled to testify by the mayor?
I think that that's dependent on whether or not this city attorney investigation is duly authorized. And that's one of the reasons why I think we need the commission to weigh in on this. I know that the city attorney's been out there serving subpoenas and requesting documents, and it's not at all clear to me whether or not that is legally authorized.
Let me ask the question a different way. Do you intend to rely on Ms. Lopez's testimony?
We haven't made that determination yet, and probably won't be in a position to give you that answer for quite some time.
As of now, I think the mayor identified the witnesses that he would intend to rely on at this point. At this point, who would the sheriff intend to rely upon?
Well, I think I'd like to reserve that, if I may. We have identified a potential universe of about 6 to 8 witnesses that we think we are likely to either submit declarations or call as witnesses, Sheriff Mirkarimi obviously being number 1 on that list. I think Ms. Peralta Haynes is likely on our list, assuming she's willing to cooperate and can be called as a witness.
And I don't think we'd hold you to this as the sort of final list, but are there others that currently are?
Well, there are, and one of the things that I wanted to bring up for the commission is I'd like to know if there's going to be some process by which the commission can take into account historical facts not related to this case. That is, what has happened in the past when other officials, sheriffs or any other type of officials, have been accused in some way, not in these types of proceedings, with having committed misconduct, because I think that can inform the commission's decision as to whether or not it's appropriate to recommend that these charges be sustained. So it'd be akin to requesting that you take judicial notice of certain historical facts. And one of the things that we may want to do is call witnesses, a witness or witnesses, to testify about the fact that there are law enforcement officers in this city right now serving who have suffered misdemeanor criminal convictions, that the mere fact of a misdemeanor criminal conviction in and of itself does not likely impair someone's ability to perform the duties and functions of a peace officer. So those are, without identifying specific people, those are some of the I guess you would call them non-fact witnesses that we could conceive of calling in this proceeding.
So that's, I mean, this is not, that's not really expert testimony. That's what sort of, what would that be intended to prove?
To demonstrate that whatever the mayor's charges are, even if any of them are true, and I think we will probably arrive at a stipulation on one or two less contested issues. For example, the fact that there was a guilty plea entered to a misdemeanor, we're probably going to be able to stipulate to that fact. But I don't think it would be necessarily, it could be characterized as expert testimony, but it could be testimony from a law enforcement officer's personal experience that that fact in and of itself doesn't necessarily rise to the level of official misconduct and is not related to their duties as a law enforcement officer.
Other than the legal issue of whether or not the commission needs to vote unanimously in order for it to make a recommendation to the board, are there other legal issues that are in addition to the ones identified by the commission staff that you think should be briefed?
Aside from the one issue that I've mentioned a couple times now, that we need clarification on whether or not the city attorney investigation is duly authorized by law, I cannot think of any other legal issues that we need to raise. Strike that. There is one question I'd like answered. We would like, as part of our briefing, to make an argument that the charges, even if everything is believed in the charges and you assume the truth of everything that's in the mayor's charges, that it still doesn't make a case out for official misconduct. And so this would be in the nature of a demurrer. We would like to know whether or not we have the ability to bring such a motion. Because we're just making it up as we go along.
Would you be, so assume for the sake of argument that we have a procedure whereby the mayor briefs legal issues, you have a week or so to respond. Would you at that time be prepared with that brief to submit the arguments for your motion to dismiss or demur?
Yes, I think we've largely briefed them in connection with proceedings in the Superior Court, so I think a week's sufficient time.
Okay. And then as far as timing of witness testimony, and I know your position, it sounds like, is it depends on when you get certain information from the mayor, but when would, if live testimony were to be heard, when do you think you would be prepared to present that and to cross-examine witnesses?
Well, there are two potential witnesses that have some conflicts with dates, but I would think certainly within 60 days. Which sounds to me like it's going to take close to that long to get to that point, probably. I'd like to be prepared within 30 days.
Other questions for Mr. Kopp from the commissioners?
Mr. Kopp, you had mentioned that you'd be prepared right now to go through the list and express your views on the standard of proof and so on.
Yes.
I think it would be helpful to listen if you're prepared to do that.
Sure. I'll be happy to do that. So I'm addressing page 2 of the memo prepared by the commission. On the legal questions, we believe that the applicable standard of proof here should be beyond a reasonable doubt. That is, before any commissioner can vote to make a recommendation to the Board of Supervisors that they should sustain any of these charges, each commissioner should have to be persuaded beyond a reasonable doubt. The reason for that, and again, I'm terribly sorry that you didn't receive our memo, but there is a state scheme in place for removal of officers for official misconduct. and it tracks all the criminal procedure protections. So I think that standard of proof should be imported into this proceeding. So that's the reason for that standard.
Excuse me, you're saying that the scheme set forth for removing officers
Yes.
is beyond a reasonable doubt?
Yes, that is true, and that is under the Government Code sections 3060 to 3075, and there are cases that discuss those, which we'd be happy to provide to the Commission. Essentially, they proceed, the DA would bring the charges, you'd go to a grand jury, get an indictment, and then trial would proceed as if on a criminal indictment. I don't want to move on if there are any other questions on that. Hearing none. On the second bullet point, on what type of evidence may the Commission rely, I think there's probably going to be some proposed hearsay testimony that we will likely object to. But without getting into, whether the evidence code should be relaxed or not, we're not necessarily opposed to declarations. There may be declarations that we're not going to have a problem with. We don't feel the need to cross-examine the declarant. But I think that there is going to be the need for some live testimony. The answer to the third question is no. In our view, the law is clear that any conduct engaged in by Sheriff Mirkarimi prior to the time that he assumed the office of sheriff cannot be the basis for a finding of official misconduct. That has been the law in this state since the Mazzola decision came down. As a matter of fact, the city attorney's office themselves have stated that that is the law. In memos they've submitted to the Commission previously, that it's got to be conduct that occurs while in office. Now, I realize they've decided to take a different view of the matter, given the facts of this case, but we believe that that answer has already been answered by the appellate court in this state.
Judge Kahn rejected that argument, though, didn't he?
He did.
Yeah.
Well,
He said you can come back to him after we've acted.
I want to be fair. I think that he characterized the focus of the opinion as dealing with another issue. But I think that the basis of his decision in rejecting our petition for writ of mandate was because he thought that the administrative procedure had to play out first. Yeah. So, number 4, does official misconduct under the charter require that the alleged misconduct relate to the sheriff's duties? I think that's unequivocally a yes. And if so, does the conduct alleged relate to Sheriff Mirkarimi's duties as sheriff? And our position is the answer is quite clearly no. And whether or not, as to the question of whether or not the guilty plea itself to the misdemeanor charge of false imprisonment, is that sufficient to sustain a finding of official misconduct? The answer to that question is no. The effect of whatever occurred is tethered in time to the date that this action occurred, which was January 1st, or most charitably, January 4th. Although, as I mentioned, I think that these allegations of dissuasion will be seen to be groundless. So the mere fact that a guilty plea was entered at some point in time after he assumed the office of sheriff, we think, has no significance for the Commission.
Obviously, were you to brief that, we would want, the factual and legal basis behind that, but thank you for sharing that. Any other questions for?
Yeah, I have some questions. First, I just want to understand about the city attorney's internal investigation on behalf of the mayor. Putting aside the question whether the sheriff has any obligation to cooperate in it, putting that question aside, is it your position that having filed the charges and preparing for a hearing before the Ethics Commission, that the city attorney does not have a right to do an internal investigation?
Not at all, sir. We think that if the Commission promulgates rules of procedure that are fair to both sides, we'd be happy to have them investigate till the cows come home, because quite honestly, there's nothing to fear here. We just want to make sure that the law is followed. And the authority we've been given as to, they aren't giving us the authority, we're doing this on behalf of the mayor. They're saying that they are authorized, the city attorney is authorized to investigate under provisions of the San Francisco Campaign and Governmental Conduct Code.
But other than trying to, or seek to interview the sheriff, are there other things they're doing that you say violate sort of fair play?
Well, whatever I tell you is going to be on information and belief. I have heard
Sure.
they're out serving subpoenas and going to court and trying to compel witnesses to cooperate with them. I don't have standing to raise any objection about what they're doing there. Well, whoever they're harassing, that person can come into court and raise their own objection.
Right.
We just feel like we've got one hand tied behind our backs. If you decide this is what's going to be permissible, you get compulsory process, you get some limited discovery, you can request documents from the other side. You either get or you don't get a chance to interview the other side's witnesses. I mean, personally, I don't think this should be like a civil trial where there's a whole discovery process. But whatever the rules are, they ought to apply to both sides.
So are you suggesting that you would like to see the commission give some rules that'll say if the city attorney is using subpoena power to investigate, we ought to exercise our subpoena power to allow you to take testimony or do whatever you want for purposes of discovery?
Absolutely. I think what's sauce for the goose is sauce for the gander.
Okay, let me go back, because I'm sympathetic with your concern about timing, because obviously the longer this gets dragged out, the person who's being most prejudiced is the sheriff, obviously.
Agreed.
The city is being prejudiced, but he has the most prejudice being posed on him. I'd like to know from you, if you had your druthers, putting aside your objections as to whether we should be doing this at all, but if you have your druthers and know you've got to put up with it, tell me how you would like to see it done to be the most speedy and the fairest to both sides.
I'd like to obtain at the earliest time from the mayor a list of witnesses and what their proposed testimony would be.
Sort of a summary of what he intends to prove.
Exactly.
Okay.
I'd like the commission to decide before we begin what the burden of proof is going to be, whether or not it needs to be a unanimous vote, as we contend, and what types of evidence will be admissible. And I think that's really all we need to know to go forward. If we know what they're going to put forward before you, and we know what the rules are going to be, then we'll get ready, and we will be prepared at the earliest possible
Now,
opportunity.
what difference does it make for purposes of your speed whether or not we tell you whether we're going to have to act unanimously?
It's probably just for our peace of mind, actually. In terms of speed, you're right. That's not going to change the way that we prepare the case. So if the commission feels it needs more time to think on those issues, that's okay.
And how long after the city attorney, say, provided you with this list of witnesses and a summary of its case, how much time would you need to prepare and get ready to go to trial, and to provide the city attorney with your summary of what you intend to prove?
I would say 30 to 40 days after that,
Okay.
my best estimate.
And in the witness list and subjects of testimony, are you anticipating something like what would be submitted prior to a civil superior court trial? Is that sort of the level of detail that you were anticipating?
I don't think it has to be that detailed. Who the witness is, if they want to give us more detail, great. But if there are taped statements, we'd like to know. We'd like to see them. If it's just a summary of what their anticipated testimony would be, that would be okay. We just need to know what are the critical facts that these witnesses will provide for you all, so that we can determine how to meet that evidence.
Other questions from the commissioners?
Anything else?
Thank you, Mr. Kopp. Mr. Keith, I think we probably have some follow-up for you as well. Following Mr. Rennie's line, do you have any objection to providing the information that Mr. Kopp just outlined?
No.
How soon could you do that?
Well, we certainly could provide a 1 or 2 sentence summary of each witness, at least fact witnesses. There are a couple of witnesses regarding law enforcement practices that we're still finalizing who those individuals are going to be. But certainly once we get them, we'd be happy to provide those. I mean, yeah. We haven't been asked. But.
What is 1 or 2 sentence? What does that mean? I mean, it's got to be detailed enough so that they understand the thrust of the testimony.
Oh, it will be.
So how soon?
As to the fact witnesses, we could supply that within a week.
And as to the police procedure witnesses?
I'd say about 2 weeks. One point that I want to.
Sorry.
Oh, I'm sorry.
Let's see if there are other questions first. As far as the legal issues, when could you have those briefed? At the same time?
Let me think for a moment. Yes, it would be. Yes, we could brief the legal issues. I'd say. Right. It depends. Again, the ones that we referenced before, we could brief immediately, meaning the standard of proof and the procedures for a hearing. These other issues, we are capable of briefing immediately all the issues on the bullet point list. But again, I question how effective that will be for the commission. And if I could give an example of sort of how the facts interact with the law here. There's an allegation that before the sheriff was in office, he told his wife he was very powerful and could take custody of her child. It's our contention that he was referring to the power conferred by the office of sheriff. Well, that act occurred before he was in office. And if that's been alleged, then the argument goes that it's not quite so simple as to say anything you do before January 8th can't be construed as being in office. So I think that these issues are better dealt with based on a factual record than in the abstract, but we can deal with them essentially based on the allegations and the charges if the commission wishes to. But a point that I would want to make would be that the commission has a responsibility under the charter to collect a full record. And making preliminary legal rulings about what things may fall outside the scope of official misconduct is going to prevent the commission from hearing facts that should be part of that full record that gets transmitted to the Board of Supervisors. So I think it would be an interesting and probably educational exercise to brief these legal issues in advance. But I would caution the commission against saying that certain types of allegations just simply are off limits, so we're not going to take testimony. So I don't think it would be useful.
I appreciate your position on that, but you could, if asked, brief those issues identified by the commission, whatever issues that were raised in your brief, and the 2 other issues identified by Mr. Kopp within a week.
Oh, I'm sorry, the 2 other issues being?
Mr. Kopp identified 2 issues. He identified the issue of what the procedure should be for conducting investigations in this matter. You were here, right?
No, I didn't I understood the issue that he referenced to be the standard of proof and what type of evidence would be brought forth in the proceedings.
No, those are the issues that the staff raised.
So he's raising the issue about whether the city attorney can conduct an investigation of city employee ethics.
His issue was, should the commission put forth procedures that govern how whatever limited discovery happens here should occur?
Oh, certainly. We would consider that to be part of what we proposed to brief, which would include not just the live hearing procedures, but procedures for disclosures in advance of the hearing.
And the other issue that he mentioned was whether the commission needs to unanimously recommend to the board whether its decision has to be unanimous.
We likewise consider that to be part of the procedures.
And do you have a position on that as you stand here, or?
No, our position is that the only duty the charter imposes on the commission is to make a recommendation. There's no statement that it's unanimous and that it need be unanimous. And as we said before, there's no limitation on whether there could be a majority and a dissent. So we don't think it needs to be unanimous.
Other questions for Mr. Keith from the commissioners? Commissioner Liu?
Mr. Keith, Mr. Kopp had raised the issue of possibly bringing in evidence of historical facts, or I think the way I heard it was similarly situated law enforcement officers who also had pled guilty to misdemeanors or who had misdemeanors. Do you have a position on that, on other situations coming into play?
Well, I think that if it's going to come in through an expert on law enforcement best practices, if they can find an expert on law enforcement best practices who can say, oh, officers can commit a misdemeanor and still be effective police officers, we wouldn't object to that kind of testimony. We'd certainly contest it, but we think it's fine. But as to specific, I don't know if Mr. Kopp may have been referring to specific past city individuals to essentially say that this prosecution, this present set of charges is somehow improperly motivated, and we think that the evidence is absolutely inadmissible for that purpose.
Okay, thank you.
Other questions for Mr. Keith?
There is one matter regarding timing that I wanted to bring to the Commission's
Please.
attention. As mentioned in our memo, if cooperation is not forthcoming from the sheriff, and we don't expect it to be, the mayor is going to amend the charges to charge him with breach of a present official duty to cooperate in an investigation.
I mean, if I understand what you're saying that you, having charged him and suspended him and charged him with official misconduct, that it's a violation if at the present time and you want to talk to him and he won't talk to you, that's a violation of his duties?
Absolutely. If a deputy sheriff in Sheriff Mirkarimi's department had committed some act of misconduct and Sheriff Mirkarimi suspended him and then told him to come in and talk to him about what happened and provide truthful information about that, and that deputy refused, that deputy would be fired immediately. And it would be lawful.
Not an elected official, is he?
It doesn't matter. Every employee has a duty to the city and county of San Francisco to cooperate with an investigation and to account for their conduct.
Okay.
Other than Mr. Mirkarimi's testimony, the sheriff's testimony that you're seeking from him, is there other discovery that or other reasons why that could affect the timing of that we've discussed that would elongate the procedure in your mind?
Well, if Sheriff Mirkarimi were to provide us with the documents we requested, which essentially was
okay,
the materials.
I said aside from Mr. Mirkarimi's cooperation,
yeah.
What else do you feel you need to have this heard on a timely basis?
We need to get the videotape from the videotape statement of Ms. Lopez from the Hall of Justice, from the court. We have a motion pending for that purpose.
Okay, but that's not the sheriff's. The sheriff has no involvement in that.
We've served him with the motion. He may or may not object to it.
Okay. What else? Please, for those in the audience, if we could, everybody will have a chance to give public comment, but for now, we would really like to hear from the attorneys. Thank you.
The next item, the other item that's pending is a motion for an order to compel Ms. Haynes to testify. That item is set for hearing on May 1st. We have some outstanding subpoenas for telephone records that are set to be responded to on May 4th. And these are those matters that I referenced earlier, where if everything goes as planned and there's no objections, then we should have the evidence and hopefully the testimony soon thereafter.
Any other questions?
What are
Mr.
the
Key?
documents that you're seeking to get from the sheriff?
The documents that he obtained in criminal discovery from the police department and the district attorney, which would include the same telephone records that we're trying to obtain by mayoral subpoena right now. It would include the videotape of Ms. Lopez's statement, and it would include whatever other materials, for example, notes of the district attorney regarding conversations with witnesses that were disclosed pursuant to Brady.
Anything else for Mr. Key? Thank you, sir.
Thank you.
Mr. Kopp, I have a couple more follow-up questions for you based on what Mr. Keith just said, and I'm not sure if my fellow commissioners do. With respect to their request to interview the sheriff, I think you've already said that you're objecting to that.
Well, let me clarify, and we are going to make sure that you all have what we think is the applicable law on this later this evening or sometime early tomorrow. And again, my apologies. We did email a letter to Mr. St. Croix laying this out.
So Mr. St. Croix was traveling all day,
Okay.
and so that's probably why
Understandable.
we didn't get it.
And maybe if we're going to be submitting things by email, maybe there will be a way to get individual emails so that we can make sure that you all have materials. But that's a topic for another day, probably. We want clarification as to whether or not they can do what they're trying to do. That's all. Because our reading of the government code section and the charter says that the Ethics Commission starts the investigation when they get a complaint. Sheriff Mirkarimi wants to cooperate with whatever legal duty he has. But we have a real problem with the authority that they are claiming. And under my reading of the charter, that's why we requested a written opinion from you, actually, as to whether or not he has a duty to cooperate with this investigation. If you tell us he does, then he's going to cooperate. But it just, so I'm not sure if I answered your question, but the fact that they then come forward and have threatened not only right here, but in a letter to us, that if you don't cooperate immediately, we're going to amend the written charges of official misconduct and add your failure to cooperate to those charges. I mean, to me, that's really beyond the pale. We have a legitimate legal question here that needs to be straightened out, and we're not going to be bullied into doing things their way because they say that's the way it's done. So,
Any other questions for Mr. Kopp?
Well, Mr. Keith responded on the documents that he said he wanted, which appeared to be documents that came into the sheriff's possession as a result of the criminal proceedings, that they weren't documents that were generated by him, but were generated by the district attorney's office. Is that right?
Well, that's part of it, but they've requested, I believe, 5 separate categories of documents. Whatever he got from the DA through the criminal case, whatever his attorneys produced to the DA, which raises all kinds of privilege issues, his own cell phone records, text message records, and if they're not reproducible, he's got to somehow get them into a reproducible form. Their request goes much further than what Mr. Keith explained.
How was material turned over to the district attorney by the sheriff's attorney? How does that have a privilege?
I misspoke, and thank you for raising that. I think they wanted documents prepared in the course of the criminal proceedings, not necessarily everything that had been produced. And We have the letter. We can provide it to you so you can see exactly what they're asking. And all we want is clarification on this issue. If you think he's got to cooperate and turn it over, we'll do it.
Is that the issue that you briefed in that memo this morning?
Yes.
Is that?
There's a letter, but we raised it, and we requested a written opinion under the Charter Code section that says that people can ask the Ethics Commission for a written opinion on these issues.
Mr. Keith, you received this letter this morning? Yes. Okay, thank you.
I mean, I could give you the code sections, but I think it's probably better to just have it distributed.
One of the difficulties, Mr. Kopp, is that everything that this commission does has to be done in open session. And so when you say you want an opinion from us, it isn't like you issued to a judge and asked the judge to give you an opinion. We have to then schedule a meeting so that we can decide how we want to respond to it.
I understand that
And I know you don't want to delay proceedings. That's what I think that's probably my number one goal here, is to try and set this up so that we can get fairness to both sides, but get it done in an expeditious fashion.
I concur.
Any other questions for Mr. Kopp? Thank you, sir. So having heard both sides, I think my inclination would be to have the parties brief the legal issues, because I think we can get that more expeditiously. I think it will help us potentially narrow the issues, but more importantly, ensure that we have the appropriate procedure in place to have a hearing. My concern with, having heard the parties, my concern with detailed factual testimony in the briefs is that while I think it would be helpful, I do have some concern that the timing may not be, the additional time may not be worth the added benefit. So I think that's, that's kind of where I'm sitting right now. It seems to me that the parties are in agreement that they could provide witness lists and summary of testimony relatively soon, which I think would be advantageous for both sides. And so I think we should strongly consider requiring them to do so. Thoughts by other commissioners on what this procedure should look like?
Commissioner Hurt, if I may.
Yes.
It makes more sense for the commission to take public comment on this item before reaching any final decisions, since it is an agenda item.
Yeah, my thought was we would deliberate, take public comment, and then to the extent that we need to make any final determinations, we would do so after. Is that?
Yes, that's fine. I just didn't want the commission to go down the road of making a decision before taking public comment.
Thank you.
So you're saying to brief the legal issues, but not the factual issues that have been outlined in the memo? Just the pure legal questions?
The legal questions that were identified in the memo and have been identified by the parties.
And they both said that they're prepared to do that quickly.
Yeah, it sounds like
Relatively quickly.
it sounds like the mayor could do that, could submit their brief within a week. Any response from the sheriff would come about a week after, and therein would be included any other arguments the sheriff had for why the matter should be dismissed. I think at that point we would likely build in some reply time, but again, it sounds like that entire briefing could be done quickly.
Well, I don't have any objection to the briefing legal issues, but I think that going forward in combination should be the city attorney, the mayor, presenting this summary of the factual issues that it intends to prove, the facts it intends to prove, which I think Mr. Key said could probably be supplied within 2 weeks, and that.
I think he said 1 week for most witnesses.
Well, he said maybe 2 weeks for the police,
right,
some of the law enforcement. So I was giving him the outside to say that he would provide the factual summary of what he would intend to prove in support of the legal arguments that they're making in their briefs, and that maybe 2 weeks after you get that, you would provide the city attorney or for the mayor a summary of the evidence that you intend to prove in opposition to the mayor's action, so that after we've made our determination on the legal questions, assuming we do make them, we would be in a position to move forward very quickly with the hearing to the extent that we decide we need it based upon the information that's been provided by the two sides.
I agree with that.
I agree as well. And then at that point, we would make a determination about the live testimony and how much is needed and which witnesses we would want to see. At that point, I think we definitely need to figure that out once we get once we see also the list of witnesses that they don't agree on that they think we need to resolve credibility issues for.
Yes, I think it's, in my mind, I still would like to reserve that question, but I think by that point we certainly would need to decide. And in addition to having the exchange of witness lists and subject matter of testimony, I also think any stipulated facts should be agreed upon or shortly thereafter, because then you will have seen what the other side intends to rely upon. And Mr. Kopp suggested there would be at least some facts that could be stipulated to, and I think we would want to know that as soon thereafter as possible.
Yeah, I mean, I've got to say, I looked at the what I will call the written charges of official misconduct, and when you get down to starting with paragraph number 8 through about 15, most of them look like they would not be disputed by either side, that they seem to be factual, historical statements. And I would think that that kind of thing we can get out of the way, and where the dispute arises over some of the allegations and whether or not the evidence supports the allegations.
Now
The timing on this would be then what? 2 weeks from now we would hear from the city, from Mr. Key?
yes, well, yes, if you could.
Sorry about that. So I'm just asking about the timing on that, so that based on what's been said, in two weeks from now, we would first hear from Mr. Key and the mayor's representatives on what they intend to prove. Is that right? And then that would be followed by hearing from Mr. Kopp.
Right.
In response, which would be at a later date. Is that correct?
Yes. So they would submit in writing a witness list with a summary of each witness's likely testimony, and we would get a copy of that. Mm-hmm. And then Mr. Kopp and his team would respond to that and provide their list of witnesses and testimony and the subject matter of testimony. I wonder, one of the legal and procedural issues that concerns me and that may slow down the process is the issue that I think it sounds like was raised in Mr. Kopp's letter of today. Mr. Kopp, is there anything, do you feel that you need to brief that in any more detail beyond what was in the letter? I obviously haven't seen the letter, so I can make no comment on whether it provides the type of detail.
Well,
And the reason I ask is because if you're comfortable with the mayor simply providing a letter brief response to that, then perhaps we would have some ability to resolve that potentially first principles issue faster.
That would be preferable, and I think that we set forth what we believe is the applicable law sufficiently, so I think we'd be, may I just have one more? I just want to make sure that Mr. Keith can understand our position, because we certainly want to have an opportunity for him to respond. But I think we've set it forth adequately in the letter, because we think that for them to investigate, a complaint has to be brought to the commission, then the commission itself decides whether or not it's going to investigate. And I referenced Charter Appendix Section C3.699-13. And so I think that we set forth the legal issues sufficiently, but I want to make sure council understands them and can respond.
What I understand is that it's from the letter is that it was a request for a legal opinion from what I could tell, I guess more inquisitive than stating a position, but we're happy to state our position on whether the procedures that Mr. Kopp discussed need to happen before the city attorney can investigate possible misconduct.
Mr. St. Croix, do you have any thoughts on procedurally, commission procedure-wise, whether, I mean, if this is a formal request for an opinion, what, if anything, is the commission staff's role in looking into it?
The opinion comes from the commissioners. The other commissioners can empower you as the chair to act on their behalf and make a judgment accordingly.
But would the staff provide a memo of some sort to, is that a staff issue? Is that
no, that's
a
why you
legal
have counsel.
issue? Okay. Okay.
If I could
Yes.
assist, I did try to identify the provision that says that any person can request that you issue a written opinion, and then the commission is required to issue that opinion within a certain time period. I think it's 21 days, but that can be extended, I think.
What section are you referring to?
It's a Charter Appendix Section C3.699-13.
So, Mr. St. Croix, if a response were to be submitted under this, if a response were to be submitted by the mayor, you're saying that we would need our counsel to advise us on, I mean, we would obviously look at the briefs and come to our views, but would our counsel be the entity responsible for making a recommendation, not the Ethics Commission?
No. You would be the entity responsible.
No, we are responsible for making the decision.
Right.
But who is responsible for advising?
Counsel is there to advise you as you reach a decision.
So even in a manner where they are, for an issue where where the sheriff is asking for a formal opinion as to whether they need to comply with an ethics issue. Okay, I just want to make sure I understand.
Commissioner, certainly I would consult with Mr. St. Croix, and together we could provide you with the advice, but I agree if it's a matter of legal analysis, I would help provide that.
Okay.
To that end, would it be appropriate for me to ask a question on this issue?
Oh, yes, please.
If I understand the issue, and I guess this is a question for Mr. Keith, that there is a city process, either through the city attorney's office or the mayor's office, that is going on right now that involves discovery intended to be used in this proceeding. Is that correct?
I would say there's three different things going on that involve ways to gather evidence for this proceeding. One is simple, I guess, just investigation, going out and asking people to voluntarily cooperate. That's happening. The other thing that's happening is that the mayor is issuing subpoenas under the mayor's subpoena power under the charter. That's another way that we're getting evidence. And then the third way that we're getting evidence is by requesting that elected officers and employees of the city cooperate with our investigation, and that's where we're requesting the cooperation of the sheriff, and that's under a provision of the San Francisco Campaign and Governmental Conduct Code that imposes a duty on all employees and officers, including elected officers, to cooperate and assist with the city attorney investigation of potential violations of the Campaign and Governmental Conduct Code. It's 3.240 of the Campaign and Governmental, of the Campaign and Governmental Conduct Code.
And regarding the subpoenas, is there a reason you are issuing them as mayor subpoenas rather than coming to the commission to request a subpoena?
The mayor has independent authority to subpoena.
May I ask Mr. Kopp a question?
Please.
It took me a while to find it, but you're moving under 3.699-12, request for an issuance of opinions, and what you're under A, it says any person may request the commission to issue a written opinion with respect to that person's duty under the provisions of this charter or any ordinance relating to campaign finance, conflicts of interest, lobbying, or government ethics. That's the section you're relying on and asking us to decide whether or not the sheriff, has a duty to cooperate under these circumstances with the city attorney's investigation.
That's correct.
Okay, so I think it would be helpful for us to, maybe I'll try to summarize what I understand are what we've discussed, and then we'll hear a public comment and we can discuss some more. But within 1 week, so I'm looking at a calendar here, that would be April 30th, we would expect the mayor's brief on the legal issues that were outlined in the commission staff memo and that were identified by council. At the same time, we would expect a response to the sheriff's letter brief that was sent to you today, and that we will take a look at as well. Within 2 weeks, that would be Monday, May 9th, the sheriff would respond to the mayor's brief discussing the legal issues that were identified in the commission staff memo, identified by council, and would include any legal bases to dismiss or demur to the charges.
I think it may be the 7th. May 7th is Monday.
Thank you. The first Monday in May is actually May 7th, not May 9th. In addition, on May 9th, the mayor would be in a position of providing May 7th. Monday, May 7th, the mayor would be in a position to identify the witnesses on which he intends to rely and the subject matter of the testimony to be given. One week after that, May 14th, the mayor would respond to the opposition brief of the sheriff. And on May 21st, the sheriff would serve on the mayor and on the commission the list of witnesses and expected testimony for the witnesses on which the sheriff intends to rely. The commission is currently scheduled to meet on May 29th. Council, are you available on that day if we were to have argument about any legal issues and further discuss when testimony would be heard, if at all? No, that's not Memorial Day. That's a scheduled meeting, Tuesday the 29th.
Counsel for the mayor are available.
May I ask, would that be in the afternoon or around the same time as this meeting?
I think the meeting is currently scheduled for 5:30.
Then counsel for the sheriff would be available.
And at that point, I think the commission would, having reviewed the briefs, having reviewed the evidence, be in a position to hopefully decide when and if further testimony would be required and in what form. But given what we've heard and the views of the commission and the attorneys, that does seem like about the fastest we can go while providing each side with an opportunity to be heard. Are there any objections from the parties to that schedule if we were to adopt it?
I just wanted to alert the commission we may need, that the counsel for the mayor may need to provide rebuttal witnesses in response, and we can let the commission know at the May 29th hearing or in advance of the commission.
Why don't you identify any rebuttal witnesses by the 25th of May?
That would be the previous Friday?
Yeah.
Yes. Okay.
Mr. Rennie has a question.
Mr. Keith, while I have you up here, and I addressed this to both you and Mr. Kopp, going along with the schedule that was suggested, would it be possible for you, when you submit your summary witness list and summary of testimony, those witnesses who you believe you could present by declaration as opposed to needing live testimony, or where you believe that you might have stipulations that you can use declarations in place of live testimony? And I'll ask Mr. Kopp if he could do the same thing with his, which would assist us then when we look at it and say, well, here's where you say these are witnesses we need live, and we can then make our determination.
I might propose that we would do that in the week of the 21st after we've each seen each other's witness lists, and I think we'll be in a good position to know what issues could be done by stipulation. So maybe if we were to submit suggestions to the commission with regard to stipulations by Friday the 25th, that probably would work well for us.
Is that all right with you, Mr. Kopp?
Yes, Commissioner, that would be fine.
That's a good idea.
These are not public hearings.
No. A couple other procedural issues about briefs and timing. Page length. Do the parties have any objection to 25 pages opening briefs, no more than 25 pages opening briefs, no more than 25 pages response briefs, and no more than 10-page reply brief?
We have no objection to those lengths.
Okay, and maybe you can just stay up here, Mr. Kopp, since there are a few other things we need to. Mr. Keith, do you have a view?
I think if we're going to be briefing the issues of the live hearing procedures and burden of proof, in addition to the legal issues outlined in the executive director's memo, I think we'll need more than 25 pages. I think something closer to 35 pages for the opening briefs.
Mr. Kopp, do you have a view?
Yes, I do. Brevity is the soul of wit. So,
While that is true with regard to wit, if I may, there are so many separate issues that I, for one, would want both parties to have the room to explain to us the standard and their view on it. And I think we would be disturbed if that was too truncated.
we're not going to object if they want 35 pages. I doubt we'll use 35, but if you want to extend them that extra 10 pages, then we have no objection.
We won't decide it by the weight of the paper.
Right, yeah, I encourage both parties to, use the pages wisely.
Extra points for brevity.
Yes.
Okay, so then 35, 35, 10. Is that acceptable?
Yes.
Yes.
Service of briefs. Mr. Keith, if you wouldn't mind, maybe you can just stay up here so we can address these issues. I assume there's no problem with email service on each other?
Actually, for us, it's preferable if we can just serve by email, and I think it's worked fairly well up to this point in connection with the writ proceedings.
That's fine with us.
Okay, so I would suggest service by email on each other, on Mr. St. Croix, Ms. Ng, and Mr. Embledge.
I agree.
Does that make sense? And let's 5 p.m. service deadlines.
Okay.
Yes.
The staff memo also outlined a procedure and what would be discussed at oral argument after briefing. Is there any objection to the parties being prepared at that time to discuss factual stipulations? And I presume not, in light of what you've told Mr. Rennie about that you would work out whatever stipulations you could after the 21st.
Yeah, we have no objection.
That's fine.
And that you would be prepared to discuss the availability of any witnesses that you intend to call?
Yes.
At that time on the 29th?
Yes.
Yes.
Okay. Probably also helpful at that time for you to be prepared to, if there are objections to witnesses, for example, if one of you decide a witness is not relevant or for some other reason should not be called, I think it'd be helpful if you were prepared to argue that on the 29th as well. Is that acceptable?
Yes.
Yes, but again, given the shorter descriptions of the witness testimony that we might receive from each other, I would want to reserve the ability to object later during the live hearing as well.
So certainly if you were objecting to a question, I understand, but I would think this would be, I'm not sure we would consider excluding a witness entirely after they had agreed to come, and so I would hope if you had an objection to a witness entirely that you would raise it on the 29th.
Certainly, if we can discern the scope of the testimony and make the objection based on the information we're given, we'll do that.
Okay. Any other questions for the attorneys while we have them up here? Okay. Thank you, gentlemen. If nothing further, then perhaps we should take public comments. Two minutes. So again, before we start the public comment, comment will be limited to 2 minutes per person. There is a clock on the podium that counts down from 2 minutes. In addition, there are 2 dings. The first indicates that there are 30 seconds left. The second one indicates that time is up. And I apologize in advance. I have no intent. I'm not intending to be rude here, but because of the number of people, we would like to. I'm going to bang the gavel and instruct that the
Does the sign-up sheet count?
microphone be turned off after the 2 minutes are up, so that we can provide everyone with a fair opportunity to make their public comment. Finally, I would like to say that public comment is not evidence, so you have every right to give your comment, but we will not be considering as evidence in adjudicating the matter the public comment that is provided here. So we look forward to your comments. Mr. Shaw.
Good evening, Commissioners. I'm Patrick Minette Shaw. Larry Bush's www.cityreport.com has a very interesting post about your collective performance, posted on his site currently. You should read it. Because after all, you have cherry-picked which cases you will hear and which cases you will dismiss. You'll remember that the grand jury cited you in the sleeping watchdog report that you had dismissed 18 previous official misconduct cases with no hearings. Then you heard the Joelle Gomez case, and you referred her official misconduct to the mayor, who did nothing. I believe you have 4 referrals from 4 sitting supervisors involving official misconduct in the Park Merced case. You've been cherry-picking cases. It's interesting that Mr. Kopp mentions Section C3699-13. You'll recall that John St. Croix used that repeatedly against me in my 2 sunshine complaints that found official misconduct against John St. Croix himself. And for 8 months, this body has refused to schedule a public hearing on the official misconduct cases that the Sunshine Task Force referred you in my case. Mr. Wildermo's Chronicle article this morning notes Judy Nadler is saying that it's important to remember this is a hearing on ethics, not on law. I've not heard one comment out of this body about ethical issues or ethical reasoning in the many months I've monitored your commission hearings. Are you suddenly going to be taking a course in ethical reasoning? Thank you.
Good evening, everyone. My name is Ernestine Waters Weiss, an activist in the city, and I am here completely to tell you that I am here in the interest of justice, not prejudice toward any side at all. As far as misconduct is concerned, Willie Brown was a mayor and a grandfather at the age of 68 when he had a child illegitimately out of wedlock, and not even a slap on the wrist. Gavin Newsom had an affair with a married woman who was wife of his chief of staff, Alex Turk. not a slap on the wrist. This is nonsense completely. I was a victim of abuse in my first marriage where my husband shoved me, punched me while I had an infant child in my arms. That's abuse. Pinching somebody on their arm doesn't mean a thing, because if you look at me, I will have a bruise. So that is not evidence of any misconduct. As far as I'm concerned, this is really ridiculous. And you, when you go over all this, should measure it very sensibly, that this is not an issue of misconduct. This is an issue where the man was not even in office at the time, shouldn't be judged prematurely by the media with mob hysteria, so they're crucifying him before he even gets a chance to defend himself. This is not justice, and I assure you, this is a very serious matter. This is where a man's life hangs in the balance, and you should take it seriously and dismiss this completely, because it's out of bounds. Thank you.
Thank you. I'm Peter Warfield, Executive Director of Library Users Association, and there is here, unfortunately, a gross disparity in so-called justice. This commission dismissed 18 cases without even having a hearing in, I believe it was 7 years. The civil grand jury called this a sleeping watchdog. Then when a library commission president violated the Sunshine Ordinance as found unanimously by the Sunshine Ordinance Task Force, and the case came before you for enforcement, you issued a letter to the mayor recommending that Jewel Gomez, the president of that commission, be sacked. What did the mayor do? Nothing. Nothing at all that was publicly visible. What happened? Nothing happened. Jewel Gomez was reelected by her mayorally appointed fellow commissioners as president earlier this year, and they didn't even have another nominee to vote for. I'll read you from your own letter of July 18th, 2011. The commission was said to have violated Sunshine Ordinance Section 6715A and 6713 for willful failure to allow public comment at a library commission meeting. The Ethics Commission determined that the Library Commission President, Jewel Gomez, willfully violated the public testimony requirements of Sunshine Ordinance Section 67.15 when she shouted down a member of the public. The Ethics Commission also determined that Ms. Gomez's actions fell below the standards appropriate for a public official. And on the bottom of this letter, the Commission voted to recommend that you consider taking steps to remove Ms. Gomez from her appointed office in light of her actions. This is not equal justice. Thank you.
Good afternoon, ladies and gentlemen. My name is Pedro Fernandez. I'm a former San Francisco policeman, spent 8 honorable years with the SFPD. I'm an investigative reporter in syndicated radio talk shows, as well as a licensed California private investigator. I'm sort of miffed at the fact that Sheriff Mirkarimi has been taken off his job without pay. Because, you know, when I look at the instances, of course, we call the pepper spray cop, where the sergeant of the police at College Bureau up north sprayed those sitting demonstrators, he's still getting paid. The chancellor just resigned last week. He's still getting paid. And let me take you back to the case of the San Francisco fire chief, when she hit her husband over the head, not once but twice, with a glass. Okay? And it was reported on the 911 tape where the husband said, "I think my children are in danger." Okay, what did Gavin Newsom say? It's a family matter. Let the family discuss it. It's a family matter. Well, guess what? Had the shoe been on the other foot and had a man hit a woman over the head with a glass bottle twice, okay, he would have been booked. I can tell you from my law enforcement career, he would have been booked, hands down. I think this is a political witch hunt. I think that Ross Mirkarimi was only the only progressive candidate on the that won election this past time at the election. And I think because of that, he's being solely targeted by the mayor's office and by different bureaucrats in the city and county of San Francisco. It's a waste of time. It's a waste of taxpayers' money, and it's ruining this man's life. He hasn't seen his wife since January. As a policeman, I saw a lady stab her husband in the face with a knife, okay? And she got back with her husband within a month, stabbed him in the face. And then the district attorney's office allowed them to go back together after a month. This man's been separated from his family for 4 months. This is an injustice, and for you people to sit here and even consider misconduct charges against him, you should be considering misconduct charges against the mayor.
Good evening, David Pilpel. A couple of points. I think the procedures that you've laid out are fair. I'm sure that they'll be memorialized in writing and available by tomorrow, hopefully, and that we'll consider incorporating them into regulations later if they work out in this proceeding. You may also want to address font size, margins, and line spacing for the briefs. It may seem trivial to some, but it may actually be material in this instance. I'm a bit concerned about the reference to the Police Officer Bill of Rights, Penal Code 832.7. I'm interested in early briefing on that to see if that creates a problem for a closed hearing or not. I would note that this really is a 15.105 hearing, so it's a hearing and recommendation of this body on suspension and removal for official misconduct. It's not an ethics complaint or investigation, so I'm not clear if C 3.699-13 applies with respect to seeking formal advice. I think that only relates to government ethics laws and not this charter provision. So I think you need to look carefully at whether you can render that sort of advice and what an officer is bound to in that instance. I hope that you'll post all the documents that have been received to date and those that are coming from both sides on the web, and that there'll be a public file maintained at the Ethics Commission that anyone can inspect during regular business hours of all of these items. And just finally, I would hope that both sides address not just the Joe Mazzola case, but the Bill Maher incident in the early 90s, and whether the mayor needed to take action there, because this certainly has application to other city officers and conduct that they may engage in now or in the future. Thank you.
Hi, good afternoon, Commissioners. Sheriff Ross Mirkarimi was democratically elected. Now the mayor is using character assassination lives, I believe, to try and illegally remove a democratically elected official. This is known as a coup d'etat, and sometimes it's hard to see a historical event when we're sitting in the middle of it. It's important that we be aware what may be going on. The sheriff is one of the highest officials in this county, and it's important. You commissioners, just like the rest of us, sit here and are victims of the same media lies every day. So it's hard, I realize your job is hard for you to now pull your head out of what you see on the TV every day and make an honest evaluation. But it's important that you try and do this and understand the historical period you're in, where you may be witnessing an actual illegal coup d'etat of the sheriff, the city and county of San Francisco. Thank you.
I'm Barbara Tangeri. On March 27th and April 3rd, 2012, I spoke before the Board of Supervisors about equitable justice. I presented my case and stated my arguments on suspended Sheriff Ross Mirkarimi. His case is in contrast to Judge Dennis Hayashi's wife, a sitting state assemblywoman, Mary Hayashi, who was allegedly a thief, and a sitting Alameda County Board of Supervisor, Nadia Lockyer, and I don't need to tell you all what she has done. But I will say that her admission, she is through her admission, she is a drug and alcoholic dependent, featured in a sex tape and physical fight, and so on and so forth. Most important, she emailed him in prison. When caught, she quickly denied it. My focus, as I see it, is Ross Mirkarimi's wife, Ileana Lopez Mirkarimi. It is imperative Mrs. Mirkarimi is summoned, whether in person or via satellite, live, to state her side of what took place between her and her husband inside their own home. There were no other witnesses, no other adults. Prior to this, all happened prior to his sworn in as sheriff. The fact is, there were no other adults. The commission, Ethics Commission, and the Board of Supervisors cannot go forward and make any decisions, any final decisions, without Mrs. Mirkarimi's input. Any decisions rendered are ruled unacceptable in the court of law, and you, Ethics Commissioners, are indeed the court of law, because it is if you do not summons Mrs. Mirkarimi, it would be characterized as miscarriage of justice.
My name is Suleiman Ghali. I'm an activist in the city of San Francisco, and a founding member of a major nonprofit organization in the city. I've been active in the city for a long, long time, and I've worked with Russ. I've known Russ, part of the work that we do in the nonprofit organization in the city. The issues that I want to raise is, frankly, can the Ethics Commission be ethical? Can you be fair enough knowing that how you got to be on the board of the Ethics Commissions? We as a voter, we as people in this city, work in the city, and love the city, and care about the city, and care about the issues that are concerning any illegal activities. We want you to know that we love this man, and this man have been in the trenches working on 6th Street, in the Mission, in downtown, on many, many issues with the community. Can you be fair? Right now, I doubt it. Right now, I doubt it. Mr. Cobbs raised the issue about previous misconduct. Yes, Gavin Newsom, Mayor Willie Brown, the fire chief White, all these issues in the people's minds. Can he get the same treatment as they did? What's with this man that everybody's going berserk about it? The other issue is election. Who was supporting who in the election? Who was Mayor Ed Lee was supporting? Mr. Herrera was supporting. Is there some sort of things behind the scene? All these issues in our mind. Please be fair and take it into consideration. Thank you.
Hi, my name is Brenda Barrows, and so I'm here in support of Ross and his family. That's what I'm here for. I worked very hard to get this man elected as sheriff. He should have been the mayor, but elected sheriff. I wish he had run for mayor. For you guys to try to just reverse that over this, because this is a witch hunt, pure and simple witch hunt. The mayor's guy didn't win. He needs to just admit his guy didn't win, and let the people of San Francisco and the people who are in the jails, who are going to suffer the most from Ross not being where he's supposed to be, suffer. So I hope you really take this into consideration and don't let yourself be swayed because you were appointed to this office by the mayor. Because you were put in here to be honest, and you were put in here to be fair, and it should not matter who put you here. It's about fairness.
My name is Francisco da Costa, and I've known Mr. Ross Mirkarimi for a long, long time. I've heard nothing about ethics in all the deliberations and all the questionings that you've asked the attorneys here, as if this is a Perry Mason type of operation. I cast my vote So did many constituents. And what I'm here to state categorically is that San Franciscans want the highest standards. From one side, I've heard comments that are despicable, as if someone is the Gestapo. This in San Francisco, your Ethics Commission have had many reports written about you, as have been stated today by those that monitor you. So do I. We monitor the deliberations very, very carefully. I know something about it, having worked for 6th Army as their last congressional liaison. I know something about Freedom of Information Act and your deliberations. What you have to do now is be ethical, to which many constituents have come here and said, to your face, I doubt you can be ethical. Thank you very much.
My name is Franzo King. I'm the Archbishop of the St. John Coltrane African Orthodox Church. I came without prepared words, but a heart that's true to the realness of what this community in San Francisco feels concerning Mr. Ross Mirkarimi. And I think it's time that the city comes together and close ranks to deal with issues that are pending, that are so much more important than something that I feel that has been overstaged. Ross Mirkarimi, I understand, as a provider for his family, has been crippled. If it is, in fact, the city's design to protect his wife and his child, then I would think that they would be more concerned about him being able to do that financially. There is this is a historical time for us with the re-entry of prisoners back into the city. I think Sheriff Ross Mirkarimi has expressed his desire to be, and his able ability to be able to aid in the success of that program. I think that there's monies that need to be diverted in other areas other than to continue to persecute a man that who has demonstrated as a supervisor and in his campaigning for the office of sheriff that he is capable and able to represent the hearts and the feelings of the citizens of this city. I would also say that there is a sentiment within the streets of San Francisco and the people that are heart of the San Francisco that are not so discouraged that he would not do a good job, but they're kind of feeling that there is a great love for a sheriff that has been to jail, one that has known what it is to fall and get up again, one that knows how important that phone call is and how important that it is that that place and that institution be ran with the dignity that we are certain that this man can do. And I want to thank you, commissioners, too, for your diligent consideration of these things. And we trust that God, as truth, will claim all victories in the final analysis. God bless you.
Good evening, Commissioners. My name is Pastor Lynn Gavin. Today we are here to experience how the 1% who control the media choreographed maneuvers orchestrated to distract and deceive the public. At its center is an assault on our democracy. With due diligence and vigor, 3 of the highest elected officials in the city, Mayor Lee, District Attorney Gascon, and City Attorney Dennis Five Aces Herrera, have pursued Mirkarimi tenaciously. Simultaneously, they have ignored my case, Sunshine Case number 11048, that found Supervisors Eric Marr, Malia Cohen, Board President David Chu, and Supervisor Scott Weiner in violation of official misconduct because all 4 of them have broken the law. This case was there before the Mirkarimi's case. Furthermore, there needs to be an investigation as to why Supervisor Carmen Chu asked Park Merced developers for $50,000 for a crosswalk in her district, which she did not disclose. She did not recuse herself from the vote on that project. That was clearly a conflict of interest. The people of Park Merced deserve to have their case to be pursued as tenaciously as this one because we are entitled to equal protection under the law. This case is going to court, and I will pursue it with every spirit in my body. I implore you to not succumb to political pressure and not be used. You are intelligent human beings, and thank you.
Hello, good afternoon. My name is Antonio Madvaz. I'm here to support Sheriff Mirkarimi and his family. I came to San Francisco because I believe the city is a city of diversity, city of fairness, city of justice. But all I see is a city of injustice and corruption. You guys should dismiss this charge and let the man continue doing his job. Suspension without pay is unfair and cruel. He's got family and he has bills to pay. So the whole thing is just a sham. It is politically motivated. You guys should drop these charges and let the man continue doing his job. Sheriff Mirkarimi is one of the best politicians in San Francisco. He fights for San Francisco. He fights for San Francisco values. This is the type of politician we need in San Francisco. I support victims of domestic violence. The victim is not saying that she was abused. She is supporting her husband. The DA dropped all the 3 charges, and he charged a new, made a new charge of false imprisonment. It's a shame. You guys should not allow this to continue. And it's very unfortunate that we are in this situation right now. This man got a lot of support in San Francisco. Even if you remove him from his job, he still has a lot of influence in San Francisco with his constituencies and people who voted for him. They're passionate about this man. He's a hardworking man. This man loves the people of San Francisco. He loves this city. You guys are doing wrong.
Good evening, Commissioners. Thank you for your time. I'm Kevin Babcock, an 8-year resident of District 10. I'm not politically affiliated with the mayor or with Mr. Mirkarimi. I think it would benefit the public if this were to be a speedy process, and I think the schedule that you've outlined sounds like it would be very good for that, so thank you. I would say that it's up to the Commission to decide how it's going to make a decision, whether it be unanimous vote, majority vote, or a consensus. I think that's really a matter of the Commission to decide. And the remainder of my comments will be directed towards the definition of official misconduct. So the City Charter says official misconduct is any wrongful behavior in relation to the duties of an office of a public official, willful wrongful behavior. As a top law enforcement official, one needs to know right from wrong, to know and enforce the law, and also to exercise discretion in situations where the law may be unclear. An unfortunate example of that might be at UC Davis, where some unarmed protesters were sprayed with pepper spray. I would say that anyone who knowingly and willfully violates a federal, state, county, or city statute doesn't have the level of impeccable moral character that's necessary to exercise that kind of judgment as a top law enforcement official. So, I recognize that Mr. Mirkarimi has many years of service to the city, and I thank him for that. But I don't believe that he's fit as our top law enforcement official because of this character judgment issue, and I think he'll have a chance to rehabilitate himself, but if in fact he admits to breaking the law of California, then he has violated the official misconduct statute of the city charter. Thank you.
Good evening. My name is Tammy Bryant, and I didn't come here prepared to testify because I didn't know we would have that chance, so I'm grateful and thank you for being here. I am here to support Sheriff Mirkarimi and to urge you to dismiss these charges for the glaring lack of evidence that any official misconduct had occurred. I stand before you as the mother of 3 who survived domestic violence 2 decades ago. I know what domestic violence is. I am a constituent who worked closely with Sheriff Mirkarimi for 7 years in our community, and with his leadership, we significantly reduced the incidence of youth homicides and the violence because the way he fought for programs that would help serve our community. And there was a tangible difference going out and not having to step over dead bodies of kids every day in our streets. And this is the kind of leader that Sheriff Mirkarimi is. I believe in him for public safety. As a person, I find him to be a gentle soul with a tender heart towards his community, towards us as constituents, but especially towards his wife and child. I have had the honor of speaking to his wife in her native Spanish and fully believe her assertion that no domestic violence occurred and resent those that seek to infantilize and marginalize her as if she has no voice, as if she is nothing. She has been reduced to nothing by these proceedings. And I think we need to honor Ms. Eliana Lopez, and we need to honor what she said. Having survived domestic violence, I know what it is, and I am confident that they're both, truthfully speaking, that Sheriff Mirkarimi is in fact factually innocent and no domestic violence occurred. This case is based on an after-the-fact hearsay statement that was fabricated for a potential custody battle. I urge you to reject wasting tax dollars and dismiss this. Let our democratically elected sheriff do his job. Our kids are senselessly dying on our streets. That is where our priorities need to be. We need him on the job right now. We are losing children while limited public resources are wasted on this travesty. With realignment and reentry and rehabilitation, he is the sheriff that we need, and we need him yesterday. Please stop wasting time. Thank you.
Good evening. My name is Christina DiEduardo. I'm a criminal defense attorney in solo practice, and it's certainly been a very educational evening for me, and I thank you all for that. I would like to just make 3 points in regard to what's been said today and some of the other comments that have been made. I would submit to you that if in the past the Commission has perhaps not been as active as it should have been with regard to some of the incidents that have been brought up, that's not a reason for it to be in dereliction of its duty right now. Obviously, like any other adjudicative body, you have to resolve each and every case as it comes to you. And I don't believe this is something where the allegations against the sheriff can be judged against some allegations against another individual. The second thing I would like to point out is that this case did not come about because of a whim of the mayor's office. It came about because the sheriff pled guilty in a criminal trial, actually rather that to avoid going through a criminal trial. Obviously, he had the option, as everybody else in this country does, to proceed forward and go to trial if he wanted to take that chance, and he could have been completely exonerated. He chose not to do that. With those two ideas in mind, I would therefore strongly request and recommend that you follow the procedure that sunlight is the best of disinfectants and provide for as much live testimony so that this cloud can be removed both from the city and the sheriff can determine if he's allowed to remain in office or he'll be removed from it. Thank you.
Good evening, Commissioners. It's my first time before y'all, although I was on my way up there before this whole incident happened because of, I heard about your insignificant value because of the committee that I was trying to get some satisfaction from, was the Sunshine. And we never made it to y'all because I heard it was insignificant anyway. But I am here totally supporting Ross Mirkarimi. Ross Mirkarimi from the Western Addition is the best supervisor we ever had. Let me also say unconstitutional. I'm up here unorthodox because I'm part of the media. I'm the only black media here at City Hall. I call it City Hall, y'all, because I done been here. I done seen a lot of things happening at City Hall. And this right, what we're doing right here is silly, y'all. Because one thing someone mentioned before, our mayors and other things have had sex, intercourses, but you didn't think that was, you didn't feel that that was getting people out of office. But here the mayor, his supervisor perhaps was having difficulties in his family, but yet you and whoever forces behind all of this is trying to create something that's really not there. The thing about it is we had a sheriff that was on point to help the people that was unserved here. And forces, let me just sing something here. My name is Ace, ooh, and I've been on this case. Some of you people out there don't want me in your face. But it's no mystery, just check the history. I'm just working on a case involved with a lot of conspiracy. Now, let me just say one thing. Without a doubt, Ross Mirkarimi is the best man supervisor we done had in our district that moved up to the sheriffs. He was going to be able to help the third world people. Now, the thing about it, if there had been Joe Blow or somebody else, then he may have had sex or something, but y'all wouldn't have had no problem with it. But what is the issue here where this city and county could accept mayors having sex, but yet the person is involved with something in his family, you criticize him like this? And then another thing, I don't understand the press just putting all this dirt on my buddy Ross. It won't come forth. I could do that because Ross is a good guy in my community.
Is there any additional public comment?
Hello, my name's Maureen Daggett. I've been in San Francisco all my life. I went to Robert Louis Stevenson. I went to APG&E. I went to Lowell High School. I went to San Francisco State. I went to graduate school here. I worked here.
Microphone,
I taught
please.
here. I've been teaching in preschools. I've been on the board of directors for urban school. I've worked all over the city with children in Head Start. I was one of the early founders after EOC. I care about all kinds of issues, and I really care about Ross. You know, my son is a friend of his. They are families together. I know from my son that he's a good family man. My son is really careful with his family. He has a Venezuelan wife as well, and I know what those tensions can be about wanting to, go see your family in Venezuela and how things work about that. I know Ross is a good man, and he's done so much for our city. He's who we voted for. He got more votes than the mayor, and we want to keep him.
Good afternoon, Commissioners. My name is Sharon Hewitt. I'm the Executive Director of the CLEAR Project, a project committed to responding to victims of homicide and violence. I'm here today to commend you for your due diligence, and I would hope that we do not inadvertently perpetuate our own collective misconduct. I'm saying today I am coming back off of several homicides that have happened in my community, and I would appeal to you that we not continue to perpetuate this and that we bring closure to this as expeditiously as possible. We need Sheriff Mirkarimi back in his position. We collectively as a city have an opportunity to mitigate the violence, to end the continued recidivism, but we need leadership to do that, and we need leadership at a physically lean time. I would ask you to consider the following. In the continuance or the extension of this continued inquiry regarding his legitimate place back at City Hall or 850, how much money are we spending? I'm a taxpayer. I want to know how much money we have collectively spent on this case. Let's end it. Let's bring those rare resources back home under the leadership so deservingly under Ross Mirkarimi. Thank you.
Good night, I think. Good evening from me. Hi, my name is Jose Morales, and I'm a member of the San Francisco Tenants Union Senior Action Network, and I'm proud to also be a member of Tenants Together, that now is 50 million tenants together fighting against injustice, especially evictions and foreclosures. And I'm here to defend Ross Mirkarimi, my friend. I admire him. I read one time in the newspaper that he was walking on the sidewalk around the city, and all of a sudden he discovered that somebody was assaulting a person, and he defended that person from being assaulted, you know. So that person that you see is strong, and all what he did, don't forget, it was just squeeze her wife's arm. He's awfully strong, but his intention was not to hurt her. And you have heard and read on the paper that he did that, and it was not his intention to hurt his wife. He was just a little bit nervous, and he made a little mistake. As a matter of fact, this same problem has been happening in the city of San Francisco to other officials that did it worse, betraying their wives. And like Willie Brown signed the 10 points of law that he will, the 10 commandments of the tenants, and he did not comply with one single commandment or promises. That is outrageous. That is really unethical. But he is one of the best supervisors, most progressive, and you should defend him. If you don't defend him, if you don't, you will not be representing our city. Thank you.
Thank you. Commissioners, I'm Terry Anders of Anders and Anders Foundation. I'm a union community organizer. I've known Ross Mirkarimi many years. He was one of the founding people to help create the Reentry Council. He speaks highly and often about the local job issues that help create jobs for disadvantaged neighborhoods. I remember him being a supervisor in District 5 and going over there to Ella Hill Hutch where they had some youth boxing matches, and the supervisor then was there. But what I really want to talk about is how the character assassination of a newspaper has vilified this person here every day. Every day. It was news. Distorted news, but it was news. What sells? I got the news here. I got the news here. Look at it here. Look at it here. Sensationalism, yellow journalism. I took a course in journalism, so I know what yellow journalism is. Very distasteful, very ugly. Took him away from his family. How could you do that? And you sat in judgment? And you sat in judgment. It should be dismissed before he even gets to go any further. But would you have the courage to do that? Would you have the courage to do that? You're talking about ethics. We're talking about law. Or are we talking about personalities?
Good evening, Commissioners. I am a community activist. My name is Mindy Kenner. I'm here to give Sheriff Mirkarimi my complete support. I would like him to go back to work immediately for the job he was elected for. As a mother and a woman, I've had long-term relationships. Stuff happens. There's a young child, upset, get into an argument, things get heated, stuff happens. That's not misconduct to me. That's real life issues that we all have to deal with in today's relationships. Enough is enough. I really, truly believe Sheriff Mirkarimi needs to go back to work. We need him. There's many people coming out for realignment, something that he has always been a part of. Thank you.
Thank you, Commissioners, for giving me this opportunity to be here and at least pour 2 minutes of my heart out to you. My name is Bob Alavi. I was born and raised in Tehran, Iran. I've been a very long time California resident since the 1960s. I would like to bring to your attention one point that no one has mentioned. Universal Declaration of Human Rights is only 32 sentences. It's not 35 pages to go in a brief. If you read that, this man and his family have been violated of every single one of those 32 stipulations. That's Universal Declaration of Human Rights, and it doesn't belong to our State Department to take to North Korea, Russia, Myanmar, China, and such and such. The other point that I'd like to bring is Mayor Ed Lee suspended Sheriff Mirkarimi on the New Year's Day, on the Persian New Year Day. And a lot of people have called that a racist move. To support that, they have stated he would have never done it to a black, he wouldn't have dared do it to a black on a Martin Luther King Day, to a Jew on Rosh Hashanah, or to a Chinese on a Chinese New Year. Again, there are, every bit of this thing is very appalling. I know it's a hot potato that has been passed down to you to cover up for the city officials who have brewed this witch hunt so far. You have the power and authority to terminate it now. You don't need to wait for the rest of the process in view of all the contradictions in the city. Thank you very much.
Good evening, Commissioners. My name is Paul Melbestad. I served on this commission for 8 years, actually longer than any other commissioner in the history of the commission. And my interest in this proceeding is the integrity of the commission. I'm proud to say that during the 8 years I was on the commission, never, while we would sometimes have disagreements among commissioners about the facts, would have vigorous debates with the city attorney about the law, never did I feel that the process was compromised because of the politics of the party complaining or the party complained of. And specifically, what I want to make sure of in this proceeding is that the same legal standard is applied that the city attorney has advised the commission must be applied in every single case where there's been a complaint of official misconduct in the history of the commission. And that is, and I read from a memo by City Attorney Buck Delventhal, who was the Chief Deputy to City Attorney Louise Rennie, and this was in a case where the commissioners were unanimous in their findings of the facts, but we were advised that we could take no action unless we found a violation of a charter or city ordinances relating to campaign finance, lobbying, conflicts of interest, or governmental ethics has been violated. Under these circumstances, the regulations make clear that no further action shall be taken on a complaint unless a specific violation of a specific ordinance or charter provision that the Ethics Commission enforces has been found. Thank you.
Good evening, Commissioners. My name is Eris Edgley. I'm a former inmate of this county jail. I am now reformed and I'm a pastor. I'm a District 5 resident. As you can see, I'm an African-American male. I'm a father. All those things represents a justice clause that we fight every day. But I want to stand here and ask for the ethics of the San Francisco Police Department of the hiring of people that destroy evidence during drug use. The former lady, I forgot her name, what her position was, but she took the cocaine and snorted up evidence, and nothing happened to her. Even Gavin Newsom was a coke snorter. He said that he was going to go to an outpatient rehab. He wasn't going inside, but he said he can do it outside. And now he's a lieutenant governor. We're spending wasteful money on this thing here. Every day, as people came up here before me and said that we're dealing with homicides in our streets, in our community. I don't know what you deal with and where you stay at, but we have actual mothers and fathers that are losing their children in these streets of San Francisco. There's been no ethics on finding justice for those families. Unsolved homicides for over 20 years. That's ethics. Let's bring the police department to this commission on their ethics on finding justice for families.
How you doing? My name is Larry Haynes. I'm with Brothers for Change, and Ross Mirkarimi, he's been very instrumental and very positive in our Western Addition area, and I'd like to see him get back to work, and he's been very responsive to our needs in our community. I think he's very honest. I know him personally, his family, and I think that this is kind of like an injustice and is politically motivated, but at any rate, he needs to get back to work. He's a good guy, and he does good work. Thank you.
Hello, my name is Merle Easton. I've been a resident of District 5 for, 25 years or so. And before Ross was our supervisor there, I was a victim of street violence. I was attacked in front of my house at 7 a.m., my face broken in 2 places, and the police were not very interested in this affair. However, after Ross came in as supervisor, he got into the police doing community policing and coordinated work with all of the departments, and I have not had any problems since. And I think that Ross needs to get back to work so that people who are doing things like the person that did to me can be given the resources to turn their life around and not be attacking other people. And I think that the ethics are in the criminal, excuse me. Thank you.
Hi, good evening. I wasn't expecting to get up here and speak, but I hear that you won't be taking public comment on this as you go forward.
This is the public comment.
All right. My name is Maura O'Brien. I am a native San Franciscan. I've worked with Ross on a number of campaigns. I've known him since 1995. I find him to be an incredibly upstanding citizen. He's been of great service to this city. He's been a part of many great changes and that have protected marginalized folks. He's greatly involved in when he was a supervisor in his district. When I had encountered violence against women, I was able to count on Ross for counsel and support. I've known him personally, but mostly professionally, and I believe that you're really doing a disservice to the city. He was duly elected. I don't feel that this is due process. I really didn't quite understand what the city attorney's office was trying to say, and they didn't really seem to be present in this proceedings. But I feel that he was elected to office. You're withholding his pay. There's really no great reason for this. You're expending a lot of city resources, trashing this man's good character, and I find that you're doing a disservice to the voters of San Francisco.
Hi, my name is Rosario Cervantes, and I met Ross back in 2007 when I was tutoring for John Sweat, and we were fighting to keep the school open, and Ross was really a strong advocate for us. and I'm also a board member for Komen Advocates, and we stand for family and children. And I've known Ross for many years, and he's very committed to the people. He's committed to his District 5, and now he's committed as sheriff, and I voted for him, and I want him to do his job. Thank you.
Good evening to all the commissioners and everyone in the audience. My name is Paula Muhammad, and I'm here on behalf of Mr. Ross Mirkarimi. I've sat here and I've listened to everything that everyone has had to say on behalf of him. And we as the people, when we elected him, we knew exactly the type of person that we were putting in office, which is Mr. Mirkarimi. My children were all born in the Western Addition. I have 8 children, and all the years of living in the Western Addition, I've never seen near supervisor or any elected official get out in the streets and do the things that he's done. I think he's the best thing that could have happened to the Western Addition. He is definitely a people's person. I feel that he has gone through enough pain and suffering. He should be allowed to return back to work with pay. To suspend him is one thing, but to suspend him without pay, that's a total different thing. He has a family. He has a child to support. And one thing I'm asking the commission to please do, and that is to have his wife return and be here to be able to give her testimony, because she is the only person that can actually tell you guys what you want to know and what you want to hear. Everything else is just stipulations on what someone else said. Unless you get it directly from her, then I personally don't feel that there is a case. I think it's a waste of taxpayers' money. And that's all I like to say.
Good evening, Commissioners. My name is Michael Tong. I'm a San Francisco City resident, and thank you for letting me speak. Thank you for your work. I know you have a hard job ahead of you. I've heard that you're treading some unknown waters here. And to the point where you can, I'd like to ask you to consider reestablishing Sheriff Mirkarimi's pay. He's been suspended without pay for the last several months. There's a lot of financial loss here. It's kind of ironic. I heard the Peace Officer Bill of Rights mentioned, and if he, as a peace officer, had been involved in an officer-involved shooting, he would be on admin leave with pay pending the outcome of the investigation. So any consideration you can give to that would be greatly appreciated. Thank you very much.
Good evening, Commissioners. Beverly Upton, San Francisco Domestic Violence Consortium. Family violence is San Francisco's #1 reported crime. I helped chair the Family Violence Council for the City of San Francisco. I've had the pleasure and honor of being on the advisory committee of many of the Sheriff's Department's intervention programs. I also am starting to serve on the realignment committee. The world is watching. The world is watching. My concern is that victims are watching. Victims who cannot come out of their homes and talk. Victims who are not here today to talk about what they're facing. And my other concern is that abusers are watching. We do not want to embolden abusers. San Francisco's domestic violence-related homicide rate is down by 80% over the last 10 years. We used to lose 12 to 15 women a year, sometimes their children as well. And I am so proud to be part of San Francisco's partnership with the community that has reduced the homicide rate to 1 or 2 tragedies, absolute tragedies a year. But the statistics bear us out. We are headed in the right direction. The world is watching. They need our leadership. Thank you.
Hello, Commission. My name is Darrell Hunter, and I was born and raised in the 5th District, the district Ross Mirkarimi represented. And I don't really know him personally, but I have seen his work in the community. And for a supervisor, I can say he was active in the community and what was going on in the community. And I had nothing bad to say about him, per se, as a supervisor. But I would like to also just bring up to your attention that
the people who made the decision why we here today for this man here, Mr. Mirkarimi, is Ed Lee made the decision to suspend him without pay and basically terminate his election, being elected by the voters of San Francisco to be the sheriff. And I just want to say that Ed Lee also hired Greg Sir as the chief of police in the middle of a police corruption scandal, and where officers committed felonies, perjury, stealing evidence, and all sorts of things. Those are felonies. Nothing was done by Ed Lee other than appointing Greg Sir as the chief of police, who was demoted as deputy chief to captain, and it was pulled to be the chief of police. So it's a lot of issues going on pertaining to law enforcement. And I personally believe that it is a waste of money what's going on here. The man was elected by the people, and the people who are making these decisions while we are here are several. Greg Sir, who he appointed, was the police, brought the evidence to Garcon, who was the police chief, now the DA. So think about ethics in that before when you go forward to making your decision. Thank you.
I want to thank the public for your comments. We are a 5-member volunteer body, and Mr. Embledge is also volunteering his time pro bono. And I think I speak for the commission when I say we are committed to having a just and fair process, and look forward to the parties' cooperation in that endeavor. Commissioners, any further comments or questions for the parties in light of the public comment? I have a couple. So could Mr. Kopp and Mr. Keith please come forward? Regarding the briefing, and again, a ministerial issue, I assume the parties have no problem with double-spaced 12-point font for your briefs. That you would, is that fair?
We agree to that format. We'll submit them just like court.
Okay, great. As far as the schedule, I want to make sure that we build in sufficient time for meaningful meeting and conferring about stipulations and rebuttal disclosures of witnesses. I know that, Mr. Keith, you said that for the majority of your witnesses, you could identify them in a week. Is that right?
Yes, the fact witnesses.
Could you provide all of them within 10 days?
Unfortunately, I have a bench trial coming up next week, so I think we'll need the full 2 weeks.
You'll need the full 2 weeks for the to identify the potential police misconduct witnesses that you were anticipating.
That's correct. Yes.
What if we had you disclose the fact witnesses in a week? The additional couple witnesses, police misconduct witnesses you identified the week after, and then gave Mr. Kopp 10 days from there to identify his witnesses.
So we'd split up the witness disclosures with the fact witnesses being in 1 week and the remaining witnesses in 2 weeks?
The remaining witnesses in 2 weeks, and then Mr. Kopp, I don't know if you're intending to identify any quasi-expert or expert-type witnesses.
It's going to depend on how we perceive the nature of their proposed testimony, but we could certainly respond with our witness list within 10 days of disclosure of the fact witnesses, and then if they give us this police expert or experts, I'm not quite sure who the witness would be. I would think that
we could probably respond within 10 days. I'd rather say 14 days just to be sure on that one, because that may, if we think we need to respond, it may require finding such an expert witness.
That's a fair point. I mean, do the parties think that would help? In other words, at that point, then the fact witnesses would be disclosed earlier, and you would then, if I'm calculating it correctly, likely have about 10 days from the disclosure of the sheriff's fact witnesses to meet and confer about fact stipulations and the like. Or is the schedule that we outlined before, do you think, sufficient time to meaningfully meet and confer on those issues?
I think more time is better, so I think the revised schedule would work better.
Mr. Kopp, do you have a view?
The revised schedule as proposed would work for us.
Okay. Commissioners, any objections? So I think the way that would look then is the mayor would disclose fact witnesses on April 30th. He would disclose any expert-type witnesses on May 7th. The sheriff would provide his list of fact witnesses on, is Wednesday, May 9th enough time? So that would be, so from the 30th to the 9th? We can do the 10th. I mean, it's a matter of a day here.
We'd prefer the 10th, please.
Okay. So the 10th for fact witnesses. The mayor would then have until then the sheriff would have until May 17th to respond to any expert witnesses that were disclosed by the mayor.
That's fine.
Does that sound reasonable to the parties?
Yes.
And then we would expect stipulations and rebuttal witnesses on the we said the 25th, I believe. So that would then give you 8 days to meaningfully figure out to what extent you can agree on issues and what we'll have to look at in terms of evidentiary matters. Is that acceptable to the commission? Are there thoughts on revisions to that? Okay, do the parties have anything else that they would like to raise with us at this time?
I think one of the public commenters suggested a single memo laying out all the deadlines and the subject matters that we're supposed to brief as set tonight would be helpful, and it would certainly be helpful to us.
Agreed.
Okay.
I've been writing these dates down, but I assume they're going to be available in written form at some point.
We will do our best to get that out, but I hope that you guys have you have team. It looks like you have others that are here and have gotten the dates, so we won't delay you in getting started on whatever you need to do. But we will endeavor to get that out as soon as we can. Commissioners, anything further?
Do we need it in the form of a motion to adopt that schedule?
My understanding is that it's that's not necessary. Mr. Embledge?
One suggestion is if the commission so desired, could it delegate perhaps to the commission president the ability to modify the schedule between now and when we next come back in case the need arises? Because this commission won't be meeting again should something come up in the meantime. I just raised that as a suggestion.
Do the parties have an objection to that?
I'm sorry, I missed the first part of that. Delegating the power to modify the schedule just to the chairperson? I don't think we have an objection to that.
The mayor has no objection?
Would that require a vote?
I actually think you already have that authority.
Oh.
Congratulations.
Great. Okay. I think that's a good suggestion, Mr. Emledge. Okay, if there's nothing else from the parties, that being the only item on the agenda.
You know what, let's
Why not vote?
avoid all kinds of future unpleasantness.
Yes.
And make a motion to empower the chair to make adjustments to the schedule and rulings according to this in consultation with the...
Is there such a motion?
Yes, I would move that we either confirm or grant you that authority to make motions and otherwise manage the process during this part of the proceedings. I think that would be very helpful to all concerned.
And I'll second the motion.
All in favor?
No.
Oh,
Public
public
comment on a motion, no.
Public comment on the motion.
David Pilpel, I just suggested it in the form of a motion so that the authority is clear going forward. So I think this makes sense, and I encourage you to pass the motion. Thank you. Bye.
Peter Warfield, as long as you're trying to do things formally and properly, I think it would be better to have a very clear motion. I thought you were discussing the schedule and had come up with a list of dates and actions on either side. And now all of a sudden we seem to have some kind of an empowering of the chair to take certain actions. So I'm not at all clear what that aspect is or what exactly you're voting on. So I think it would be useful to state the motion clearly as to what you're voting on. Thank you.
Any other? Mr. St. Croix.
So I suggest you make a motion to empower the chair in consultation with the interested parties to make adjustments to the schedule that's been laid out for tonight.
I think that motion has been made
Yeah.
and seconded. And so the purpose of the motion was not to change the schedule, but if the parties had sometimes in these sorts of things, issues come up where dates have to be modified slightly, and rather than slow down the process by requiring the entire body to meet over a routine administerial matter, this would allow the chair to handle those and allow the process to move smoothly and as quickly as due process will allow.
I understood the question. I think the motion is clear. I think the question that we got, although we don't usually respond directly, is where did the schedule come from, since the schedule has been adopted by agreement with the parties and was not adopted by motion. We are being more formal about your authority than we were about the terms of the schedule. And I think if that's the proper procedural step, it would just help to clarify the weight that the schedule has and why you were proceeding as you did, and either after voting on the motion or before it.
So what are you? I'm not sure I follow what you're suggesting we do.
I was simply suggesting that you clarify why the schedule can be put into place without a motion, because its source of authority is different from what we're voting on now. That's all. That we don't, just saying that we don't need to vote on it, if that.
Yeah, I think
you said it, but it wasn't.
Okay, yeah, well, to be
heard by the
perfectly
audience.
crystal clear, the commission does not need to vote on implementing a procedural schedule, so that is why the commission did not vote on it. The agreement that we discussed with the parties is the procedural schedule. There was no objection from the commission, so that is the schedule that will govern going forward, absent a administrative request for some modification if there is good cause or something like that. So with that, all in favor of the motion that was put forth by Commissioner Studley?
Aye.
Aye. Any opposed? The motion passes. Thank you all for your patient participation in this. The meeting is adjourned.